corrected.
It's good.
Oblige, Lordships.
Yes. Item 2. Go to prayer. Emergency. 2024 matter na? First week of February. Item 3.
Item 3, your lordship, call me after vacation.
After vacation. Yes. Item 4 has been disposed of. Item 5.
May I appeal, Your Lordship? Yes, the petition challenging the selection procedure of the selection of the junior teacher. But as per the resolution, my lord, the merit list should be prepared as per the district wise. But
You have given representation.
no,
Give representation in terms of government resolution dated 22/8/23.
see, my lord.
They will consider.
Yes.
Petition prayer needs guidance. Counsel for the petitioner, having argued the matter, now submits that liberty is claimed to make an appropriate representation.
My lord, I am
in terms of resolution.
challenging the selection procedure, my lord.
See, what you are saying is follow the government resolution dated 22/8/2023. For that, you give a representation. I will direct them to consider.
My lord.
I will tell them to reconsider this.
Yes.
22/8/2023. Pattern is therefore. And if
Clause 8, my lord. Clause 8, my lord.
Huh?
Clause 8, the resolution are already clearly violated.
Give that representation, they will consider, sir. Whatever it is. 8/2023, connect therefore, and the direction is issued to consider the same in a time-bound way. Justice will be meted out to his client. First, with this proposal, Mr. Lenka, Learned AG, appeal for the office is also agreed. First, in the above circumstances, petition is disposed of, permitting the giving liberty to the petitioner to make the appropriate representation within 10 days.
15 days.
15 within 2 weeks. And if one is made accordingly, the same shall be considered by OP number 1. OP number 1. In the light of subject representation. And a fresh decision would be taken on that basis. But all contentions are kept. Item 6.
I am seeking a review of your lordship's order. If your lordship sees the order, well, in fact,
You were not party.
I was a party.
No notice was issued.
No notice was issued. But why I am seeking a review? The self-same petitioner and the self-same lawyer filed a writ petition, got an order. I moved an application for recall. The order was modified that I will challenge the maintainability of the appeal before the appropriate forum.
Then take notice.
Well,
Take notice.
he has not brought these facts to your lordship's knowledge.
Issue. And without notice, we have disposed of the matter to consider.
Yes, representation. But in fact, can there be two similar proceeding by the self-same party in two different forums? There's an appeal is pending.
Issue emergent notice.
I'll take to OP number 1 only, who was the writ petitioner.
No, all you have to take, na?
My lord, only the writ petitioner he had got an order to consider.
No, we do not know what others have done pursuant to our order.
All right.
This learned AG requested to accept notice for 1, 2, 3, 4, 5, 7. Up to 7, na?
7.
1 to 7. Emergent notice to rest of the partners. No, please. Okay.
My lord, I have filed an application for stay because if that proceeding continues, it will be a double jeopardy for me because two proceedings are parallel to each other.
Any proceeding would be subject to outcome of this petition.
Yes, grateful.
I dispose.
Item 7.
Claim for equal pay at par with the state government lecturers, your lordship, has been rejected by the opposite party under Annex 1. And in a similar matter, this honorable court has already issued notice.
Mr. Lenka accepts notice for this.
Obliged, Your Lordship.
Goes to title. When I say notice, you should immediately take me to the title. For State Selection Board also you appear.
The separate panel.
Separate. Emergent notice to 3. First, it is open to petitioner to serve a copy of the petition on a panel counsel who usually represents.
Patnaik, yes, sir.
Patna. Yes.
Item 8. My lords, I am petitioner for.
We have that.
I am petitioner for item 8.
Yeah.
My lords, I am petitioner for item 8. There are similar pending cases before your honorable court, 18 cases. I pray to tag all these cases and I pray for hearing all the cases during 3rd week of January.
Issue
I have
notice.
given the
He requested to accept notice for. Go to past title.
All matter.
All.
Yes.
Call these matters along with.
No matter.
Huh?
Sorry, Your Honor.
Yeah, all.
No.
District is this.
4 is something else. Regional Director, National Institute of Open School.
Okay, urgent notice to 4.
1 and 4 to notice.
1 and 4 also.
Yes. Chairman, National Institute.
Is not open.
Yes, sir.
1, I issue emergent notice to 1 and 4. Mr. Lenka, learned AG on request appears for rest of the weeks. Correct?
Yes.
Oh.
item 9.
Matter along with which is the, where is the list, brother? Given.
I have already provided to the court master, sir. I have already provided 18 cases similar.
Item 9.
Your Lordship, item number 9, I'm appearing on behalf of Sakarika Sahu. I may be permitted to withdraw.
You want to withdraw?
Yes, Your Lordship.
File a memo. Yes, give it. Yes. Next.
Item 10.
My Lord, Advocate Sandarani Pani from BC Barampur, my Lord. This is a claim of RACP and the several cases are already complied, my Lord. But NHL 7 is pending, representation is pending, my Lord.
If representation is considered, will you be happy?
Not considered.
No, therefore, for direct consideration of your representation,
Okay, my Lord.
petition prayer read by the counsel for the petitioner draws attention of the court to go to prayer.
Yes.
Prayer to the representation. Date of representation is what?
24/3/25, my Lord. That is page number 28.
What?
24/3/2025, attorney Mr. 7. Very. The request is made for sanctioning of rate pay of rupees 5,400 and rupees 6,600 under RACP scheme after completion of 20 and 30 years respectively in service. First, the counsel for the petitioner submits if a direction is issued issued for consideration of the subject representation, it is claimed to be satisfied. With this proposal, Mr. PGA, Mr. Lenka is appearing for the decision. So please,
1 and 2. I am appealing for 1 and 2.
who should take the decision?
Okay, number 1, my Lord.
The university matter.
Correct, but RACP, the benefit has to be.
Now all the power has been delegated to the university. By notification.
Appears for OP number 1. First, notice to OP number 3 is dispensed. To whom you have given representation, madam?
To all the parties, my Lord. But
You are not telling who should take the decision, na?
no, OP number 1 will take decision, but I have given representation to all the OPs.
You just look into, if you have to take decision, you take. Otherwise, forward it to OP number 3.
Yes, obliged.
In the above circumstances, you have to write one sentence, no? Subject counsel for the petitioner submits that the decision has to be made by OP number 1. Whereas the learned AG appearing for 1 to controls the position and says that it is OP number 3 who has to take the notice. First, the dispute as to who has to take the decision need not deter the court from directing the jurisdictional authority to take the decisions. First, notice to OP 3 is dispensed with, since the prayer is for passing an order on the subject representation, keeping open all contentions. First, next one, in the above circumstances, petition was placed in law, directing OP number 1 to take the decision on the subject representation, or to cause a decision to be taken at the hands of OP number 3, in accordance with law, and within an outer limit of 2 weeks. First, it is open to jurisdictional authority to solicit any information, document, etc. Delay shall be viewed very seriously. First of all, contentions are kept on.
Item 11.
Registration and copy are 43.
Passover.
Passover, what is this matter, madam?
So my file is not with me. That's
All right, I'll
Passover.
They appeal this to termination.
termination.
Disciplinary proceeding.
No. 11.
And it's a 3.
11, na?
There's the
It's a number.
The petitioner.
When you
Removal order.
it's to withdraw his resignation.
You want to withdraw.
Withdraw his resignation.
Is it accepted?
Oh no, sorry. This is another case. So sorry.
No.
The file is not for Passover, please, your lordship.
Issue notice that the AG has requested to accept notice for. Go to cost item. All OPs.
All of these.
Okay. Next.
Item 12.
The matter is covered by Hemant address. Similar matter.
Have you changed it, corrected the You go. Subject to appeal. Yeah.
Item 13 has been disposed of. Item 14.
Regarding RSC matter, my lord, rejection order is annexed 8.
Then we have issued notice.
Yes, sir.
Issue emergency notice.
14, 15, 16.
Notice for go to cost title. Why new person has come? Where is man? Our man gone? He's working here. Yes. Go to cost title. The DGA Mr. Lenka accepts notice for all OPs. Call this matter along with WP number.
14, 15, 16, same manner.
No, that's all right, but there are other matters now.
What I know.
You have that. Follow that matter along. So, next.
Item 17.
May I please, Lord? This is the present petitioner claiming the service continued. Your Lordship, in similar matters issued notice.
Issue emergency notice. DGA Mr. Lenka accepts notice for all this matter along with WP. Next.
Item 18.
My Lord, kindly see the prayer.
I saw that, but I am unable to understand what the prayer.
Yes, my Lord. My Lords, now.
Mr. 14%.
Yes, my Lord. My Lord, he alleges that he has not been cooperated by the staffs of this registry, my Lords. My Lords, now this is communicated by message. Through message, the listing of the cases are communicated. He was not present, that is why his case was
With
dismissed.
Passover. Otherwise, he will file a case against me also. Passover.
Otherwise, your lordship may adjourn, they might have.
But why you very, what is there in this matter?
My lord.
Absolutely nothing. What registry people should
My
they
lord.
work under a lot of
My lord.
sometimes some
My lord.
miss what to do.
Item
19 please, ma'am.
Yeah.
19
Item
please, my
19.
lord. My lord, this is a matter of release of annual increment. In similar matter, your lordship needs to notice.
Yes. That was they would but the AG requested to some notice was why so all along with the
Item 20, 21, 22 have been adjourned. Item 23.
May I please?
Yes, sir.
Similar order, your lordship has passed, my lord.
We have already Sharat Chandra.
My lord. देखिए कौन
Subject to appeal 197.
yes
Item 24.
obliged.
Go to prayer.
Prayer.
Payment of all the first of the prayer needs saddened. First, Learned AGA appearing for the notice submits that a writ of mandamus should be preceded by demand and rejection, and in the absence thereof is not maintained. First, this view is echoed in all standard books on law relating to this, like the one by Professor V.G. Ramachandran. Next one. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation in respect of his prayer to the jurisdictional authority within 2 weeks. And if one is made, the decision shall be taken by such authority within an outer limit of 8 weeks. First of all, conditions are kept open. Delay shall be seriously open to solicit. Next.
Item 25 has been adjourned. Item 26.
Your
My prayer is, my lord, to grant and release trend graded scale in favor of the petitioner as per the government resolution dated 16th November 2020 of school and mass education.
My lord,
I have made
Annex
a
12 is pending, my lord. Annex-
That is not bad. As per the common qualification, that was also allowed in the, as per the
your
government
representation-
resolution of school and mass education.
representation.
Yes, I have filed a reference.
Annex
under
12.
12.
Annex 12.
Yes, my lord.
Petition of the year.
To the Director of Secondary Education, Orissa, Bhubaneswar. On dated
The petitioner.
21st
petition of the court
August.
to the representation dated 21/8/2024, a copy whereof awaits at Annex 12. Wherein request is made for the sanctioning of DG scale with retrospective effect and to grant consequential benefits on the basis of value addition by way of MA in Hindi. First off, learned counsel for the petitioner permits that complaint will be satisfied if a direction is issued to consider the subject representation in the light of government guideline within a reasonable time. First, with this proposal, based by the next part, 8 weeks. Next sheet.
Item 26.
26 मिला RSC मैटर मिला तो गवर्नमेंट में सरस्वती भूमि मिला
Item 27.
27 मैटर इज कवर्ड मैटर
What is that man?
ये शुभेंदु नायक इज कवर्ड मैटर
You next. Have you given copy to others? But prayer is also same.
माय लॉर्ड
You will give representation and they will consider.
यस
Yes.
Annex, he has given representation, but it need to be before
Let him
the
give a fresh.
press.
Item 28 has been adjourned. Item 29. Item 29.
Washing of advertisement. And it just we go to annex
29.
B.
Service.
Take notice. Where I requested for such notice for. There are all of these. Go to first. Yes, all of these. District welfare officer also.
Yes, yes.
Office also. Yeah.
Item 30. Item 30.
Same. 29 and 30 same. Any selection shall be subject to outcome of the bidding.
Item 31.
Everyone should, I guess, subject to the outcome, your lordship cover.
Yes.
Item 32, my lord.
Item 32.
Petitioner seeking an enhancement of credit pay from rupees 2,800 to 4,200, my lord, or similar to Saraswati Bhai case, my lord. Lordship has passed this order. Same order may passed.
Same.
Item 33 and 82, 81 also same. 33 and 81.
37.
33 and 81.
33 and 81. Yes. Sorry.
Item 34 has been adjourned. Item 35.
34 adjourned.
My lord, with the rehabilitation appointment, your lordship, I have corrected. My lord.
They should know what you are thinking. Name of
Bonta तुमचं
maybe as a government policy, pending appears for.
But I pray one thing. Opposite party number 4 is the competent authority to decide the matter. That is not reflected. I say.
Item 36.
Petitioner was the senior most assistant teacher of a school, aided school. He was working as headmaster in charge. Now he has been no regular appointment of headmaster, but district education officer now issued a letter at page 66.
31/10/25.
Madam.
What it says?
It says this is to inform you that the inquiry officer, after thorough inquiry on 29/25 into the different allegation petitions, suggested the following action to be taken at your end. The headmaster of the school, despite being a TGT, is a classical teacher, which against the rule. So he should replace the TGT art school by selected as the headmaster in charge.
You take notice.
Madam.
It is requested to something about this. Yes.
Sir, my lord, 1 to 3.
Interim status.
4 is to.
Status quo. Mr. Monty appears for whom?
1 to 3
2
minutes.
3 emergent notice to form an application supported by affidavit in IA number 2173 of the
Continue करजो.
5 in point seeking the interim protection. First one. Council submits that unless interim protection is granted, great injustice would be meted out to each claimant. First of, there is some course in this submission. First of, in view of the above, matter will deeper consultation. In view of the above application being in favor, parties are directly to maintain status. till next week of hearing. Also, it is open to the other side to seek variation of this order. If you don't do it, this is fine.
Item 37.
May I please, Your Lordship? My Lord, the present petitioners approach this honorable court with the limited prayer to consider the representation for a backlog ST vacancies.
Quashment also you are sought for.
My Lord.
Report dated 15/10/2024
My
to
Lord.
be quashed.
Yes, my Lord.
Let him take note.
My,
This is notice.
You appear for whom, Mr. Bonti?
Sir, my lord, for the OP number 1 million, 1 and 2.
Huh?
1 and 2, 1 to 3 million.
1, 2, 3. No, all.
No, my lord, all. Because BO is there.
Yes.
my Lord, please.
Item 38.
Go to prayer. Appeal,
Impugned order is at the annexer 9 million.
direct the secondary education.
Exactly.
Required consideration.
Yes.
I can't dismiss that application. Yeah. Issue emergent notice, go to first title. AG is requested to accept notice for 14 numbers 1, 2, 3. First emergent notice 2, 4, and 5. Yes.
Item 39.
Yes, my Lord.
And it is in respect of that guest lecture.
Impugned advertisement to be questioned. What we have done, I think 3A, that 3AB, no. The other, today only we have issued emergent notice, na?
Item 29, 30.
29, 30. Same one.
29, 30, 30.
29, 30. Subject to outcome of, you have not filed any application.
Yes,
No IA is filed. IA is filed.
yes.
Yes, the same order as we have done. All along with 29, 30. Yes.
Thermal is pending on this,
Huh?
pending, it is or disposed of.
No, pending.
Pending notice
Because
to issue.
those two we have to, quashment is sought for. Yes.
Item 40.
May I please, Your Lordship?
They say that cutoff age relaxation ought to have been given, which
Are
you have
there-
not given. Is that correct?
As they are continuing,
Yes, yes. That we have admitted those matters. Yes, 41.
Item
Lord.
40.
40, item 40. May I please, Your Lordship? Your Lordship, challenging the inaction of opposite party in not paying the petitioner service benefit, pension, and earned leave, Your Lordship. This is a second round litigation, Your Lordship.
Second round litigation.
here Miller, I have gone through that first order. It has pays 20 million. So far the pension and gratuity, this has already been released as it is revealed from this order itself. Possibly they are for the interest on the delayed payment. And have a glance on list 20.
Your Lordship.
Since the final pension and the gratuity has already been released in favor of the petitioner, then counsel for the petitioner doesn't want to pursue this application. This is in past instance.
But the interest.
Possibly for this purpose. Padmanabhan.
But you.
No, Your Lordship, they are not.
My lord, if at all asking the same, they will file a fresh representation.
Representation seeking
Your
interest.
Lordship, in annexure 8, we have already filed a representation, Your Lordship.
Very sad.
Page 21, Your Lordship.
This is at annexer 8 million.
But earned leave, delay, gratuity on the above period amounting so and so. First. Right now. Petitioner having retired was not paid certain terminal benefits like pension and other. First off, he was before this court in earlier round of litigation in WC number
31843
of 2024, and a coordinate bench of this court. Why the order dated
26 million.
26/3/2025.
25.
At the para 4, 3 and 4, third as an person. But that counsel for the petitioner submits that in the light of the above order, his client has already filed a representation dated
Representation dated 15/7/25.
16/7/2025 at Annexure
Annexure 8, page 21.
The next page.
Annexure 8, wherein he has sought for the benefit of earned leave surrender, and interest on the delayed payment of certain terminal benefits like gratuity, etc. First, counsel for the petitioner cite decision of the apex court in which is that Padmanabhan Nair, State of Kerala versus Padmanabhan Nair. Padmanabhan Nair. Just look into it. 85 Supreme Court.
Yeah, yes.
AR 85. Is that? What is that?
That is 1985 AR 56.
Just right. First, Lovely DGA, Mr. Mohan submits that since such a prayer was not made in the earlier round of litigation, petitioner is constructively restituted and therefore no money can be granted to him. Him or her?
Him, you know.
This is a hymn.
First, having so contended, now he agrees to instruct his client, official clients to look into the grievance of the petitioner in accordance with law within a time-bound manner if all contentions are kept open. First, counsel for the petitioner is agreeable with this proposal. It's 12 weeks. Open to solicit. Yes.
Item 41.
41, Your Lordship, case relates to regularization. Second round litigation, my prayer has been rejected. The notice is to be issued.
How many years of service?
That is, Your Lordship, more than 30 years of service.
Issue emergent notice. AG is requested to.
Here, my lord, there are panel of laws that agricultural university. Go to first.
Opposite part number 1 and 2, that is notice is to be issued. But my friend will accept notice for 3 and 4.
We issue emergent notice to 1 and 2. AG, Mr. Bonti is requested to accept notice for 3 and 4.
Item 42.
To my lord, RSCP Asama similar matters from 54 to 59.
54 to 59.
54 to 50.
Same date. Same dates. Dates will vary.
No, date has not been mentioned.
Not mentioned.
No. Date of order only sent. No date mentioned. 54 to 59, sir.
54 to 59. Yes.
Item 43.
May I please, Your Lordship?
Yeah.
Lord petitioner pray before Lordship to consider the representation under Annex 8 for promotion to the post of Principal Diet, my Lord.
Any junior is given promotion.
My Lord, a junior, in the decrease proceeding, my Lord, a junior name has been recommended under page 22, my Lord.
Your name is not recommended.
My name below that stated that therefore due to want of par/CCR. But in fact, under Annexure 5 series, my Lord, I submitted my par in all CCR in due time. So consideration under Annexure.
Consider representation.
Annexure 8. Annexure 8. Because the cadre is there, let it be considered.
There of the petition. There in the petition reads as well. Counsel for the petitioner submits that he has already made his client has already made a representation dated 18/12/2024 at Annexure 8, seeking grant of the motion. As much as the juniors are recommended for the said room. First, he also draws attention of the court to the observations made by the DPs. First, he further submits that if a direction is issued to consider the subject representation in a time-bound manner, his client would be satisfied. Next one, Mr. Mohanty is on a DG appearing for the office. Opposes the petition contending that there is no right to promotion as such, although right to consideration of the case for promotion is made available to employees. Having so contended, he agrees with the suggestion of this court to instruct OP number 1
One, my lord.
to consider the subject representation on the condition that all contentions should be kept open and a reasonable period being granted for such consideration. First, with this proposal, counsel the petition disagree. 8 weeks. Open to solicit.
Obligatory.
Item 44.
So item 44 is for RSCP, it's a cover matter. I have correction. Made the corrections. Nice.
Item 45.
If I want the second law litigation, now the
Issue. What is the issue?
what we put?
No, sorry.
You give your fee to her.
Sir.
Yes.
Lordship, my lord, that is the scale of a higher scale of claim. That the petitioner, physical education, my lord.
BSc PhD.
BSc PhD. That now getting the matrix CPED, my lord. That is the on the basis of ratio decided by Niranjan Naik case, my lord. The allowed to ICPED. That
Have you made any representation seeking?
My-
Annexer 7, my lord.
my lord.
Next, just 7.
Page 38.
Coordinate means also pass the similar cases.
Petition prayer reads as first. Counsel for the petitioner submits that the facts of this case are substantially similar to the one in WP number 13112 of 2021 between Rajiv Kumar Sahu versus State of Odisha and others, disposed of by a coordinate bench of this court by order dated 19/2/2021, and therefore the same benefit be extended to her client as well. She also points out the representation dated
26/7/2025.
26/7/2025 at another 7, wherein the request is made for the grant of the said benefit, and therefore a direction be issued to consider the subject representation in the light of Rajiv Kumar Sahu Supra. First off, with this proposal, learned AGA Mr. Mohanty is agreeable, provided that all contentions are kept open and a reasonable period is prescribed. First, next month, 8 weeks. Consideration of representation could take place in the light of the decision in Rajiv Kumar Sahu.
Item 50 also same, my
50.
50, my
What representation dated?
26, my
Same.
my lord. Same district. Annexure 7 also.
Okay.
Item 46.
You have the second law litigation. Now that they have rejected my claim, you'll also already issued notice in similar cases.
Call along with the WP number.
I've given that.
Yes.
AG accepts notice. Call along with WP numbers rights.
Item 47.
Advocate Sandarani Pani from BC Barampur, my lord. This is also claim of RACP. Representation is pending annexure 12. It is similar as that of item 10, my lord.
Item 10. Annexure dated
Annexure 12, representation is annexure 12, my lord.
Yes, this photo.
Item 48.
My lord, second round litigation, earlier I came, rejection order is annexure 11. Notice is to be issued.
This is AG request for Any connected matters are there?
No, my lord.
I am for open number 1, 2 and 4. 1, 2 and 4. 1, 2 and 4. Yes.
Item 49.
Wrong fixation of RSAB. Similar matter already issue notice.
Issue notice.
Item 50 has been disposed of. Item 51.
What is the applicant challenge the annex?
What has happened to your
Column. Yes, 38 disposed, punishment has been awarded 16/7/2024. He has not preferred the appeal. As per the rules and also 3 months for the prefer the appeal. Liberty may grant the
appeal?
Prefer the appeal.
But the 16/7/2024 order.
Because he has got the some documents in Annex 11, 18/7/2025. Page 47.
What is the penalty order?
Penalty order is the lordship, page 39. He censured one in annual periodical increment is stopped without cumulative effect. Period of suspension is treated as leave as due. That's it before.
Petitioner having suffered order of punishment in a disciplinary proceeding is knocking at the doors of report for laying a challenge to the same. First, but that counsel for the petitioner submits that the impugned order has several infirmities and therefore the court should undertake a deeper examination of the same. First, learned DSC, Mr. Sen appearing for the OPs points out that petitioner has got a remedy of departmental appeal and therefore he should be relegated to the said remedy. Commas, there being no extraordinary case for indulgence of the read. With this proposal, the counsel for the petitioner is agreeable, provided that some reasonable time is granted to him to prepare the appeal with a direction that if such appeal is filed, the same should be disposed of expedition. This is next in the opposite the petition is disposed of, reserving liberty to file the appeal within 2 weeks, along with an application for condonation of delay, supported by a superior. First, if such appeal is filed, the application for condonation of delay shall be viewed very leniently. Then some explanation is offered in the writ petition itself, and the final decision to be taken on the appeal as expeditiously as possible. First, all conditions are kept. Within 2 weeks, you have to file the appeal. Get well soon. Yes.
Item 52.
In item 52, the petitioner prayed for the revised scale of pay as per Annex of 3, my lord, and the representation under Annex of 5 is pending, my lord, before the opposite party number.
Prayer reads that counsel draw the attention of the court to the representation dated.
Representation dated, my lord.
10/2/2025.
2025.
I submits that direction is issued to consider the subject representation in accordance with law within a reasonable time. His mind would be satisfied. This proposal, but the DAC appearing for the OPC is fairly agreed. First, 8 weeks.
Item 53.
Item 53, Your Lordship, this is a covered matter as per Your Lordship's order. I'm passing on.
52.
53, Your Lordship.
53. In covered matters, you should have a copy of the other side.
Yes, Your Lordship.
Yes.
Item 54 to 59 have been disposed of. Item 60.
And Lord, here the petitioner has filed this writ petition.
Execution case to be disposed of. More than 6-year-old.
6 years.
Petition prayer reads as that. First, counsel for the petitioner submits that in view of Rahul Shah versus so and so, 2021 SC, come on. All execution proceedings have to be accomplished within an outer limit of 1 year. And therefore, a direction be issued to the executing court to accomplish the law. First, there is force in this submission. Next one. Notice to OPC is dispensed with since the direction is innocuous. That is, for disposal of the long pending execution, number 178, execution case number 178 of 2019. First, right to speedy justice is a precepts of Article 21, of the Constitution. Needs no mentioning. First, next one, in the above circumstances, petition needs disposed of, directing which court?
State Education Tribunal business.
OP number 4 minutes. OP number 4. To hear and dispose of the subject of the execution case within an outer limit of 6 months. I like 6 months. All conclusions are kept open. Then to send a copy of this order. Not necessary. You are representing, not? Melon. Okay. For all the approach, same appears for this. Yes.
Item 61.
May I please, Your Lordship?
Why, brother, why you are not complying with the order of the tribunal, the consent order in execution?
Not
6 years.
since 2019 months.
Why? Why there should be execution? You have seen the latest judgment of the apex court now. Even for execution of money decree also, there need not be execution at all. The court which passes the decree, that itself should execute. Yes.
May I please, Your Lordship? My Lord, the claim of the petitioner is for grade pay of 4,200 in view of the judgment of this honorable court decided in the case of Saraswati Koi, my Lord. My Lords have passed number of...
Representation is there.
My Lord, representation is at Annex 6, my Lords.
You have changed all those things.
My Lords, my Lords.
Yes.
Item 62.
The petitioner is a retired head clerk, but he is entitled to get certain benefit. He had earlier approached this honorable court also, but those benefits were not given to him.
What the court said?
Well, the court directed for consideration of this case, consideration of his case.
Thereafter what?
Thereafter he filed a contempt petition, and contempt petition was also disposed of that to comply that order. But
again one more order.
Again.
And now how if I pass another order, they will do the same thing.
Your Lordship, may I direct the State Council to take instruction in the matter.
Madam, Mr. A.S. Hussain is requested Dr. Notice for matter lies in a narrow purpose. And it is a second round litigation on this line. In the second week of February 2026.
Item 63.
May I please, my Lord?
Yeah.
My Lord, if my Lord allows one sentence, as an advocate, it eases when one gets a case to argue. But there are certain cases which actually displeases very much, disturbs rather. This is such a case. My Lord, here, the government has taken a decision to abolish all the libraries from the schools, Your Lordship.
Abolition of libraries.
Libraries from the schools.
Like burning Nalanda libraries.
This is unthinkable, sir.
Why is that decision, brother? For abolishing the library. This is a country known for libraries and universities. Nalanda, Takshila, your Orissa universities also, 3 universities, oldest universities. Should take it from this. Mr. A.S. requested to accept notice for OP numbers.
All of these.
All of these.
My Lord, stay operation on Annex 3.
Consent for the petitioner draws attention of the court obligation in IN number 22598 of 2025 supported by affidavit. Wherein will stay of the order dated
6/12/2020.
At the next
3, my Lord.
3, whereby libraries in all schools are sought to be abolished. First, he tells the court that that would be very drastic. And contrary to the traditions and ethos of this country. First one, a case is made out for a deeper examination of the matter and for issuance of interim protection. First, in the above circumstance, application having been favored, the impugned order is stayed until further orders.
Item 64.
64, my lord, this is covered by Saraswati Bhui. All connected matters are similar.
Have you added that?
Yes, I have added.
Give that. Yeah.
72 and 76 are also similar.
72
and 76. And so far as item 64 is concerned, all connected matters are also similar.
76.
72 and 76.
64 all connected matters.
All connected matters.
Next.
Item 65.
65, my lord. Kindly see page 58, my lord. 58, my lord. Earlier, my lord, I approached your lordship, paragraph 5. Your lordship dispose of the matter directing to the opposite party not to consider my representation taking into account Annexure 3 series, my lord. But till they have not considered, I file a contempt. Contempt is dispose of time, giving time 1 month. For till today not consider, my lord, by small prayer, my lordship directly again to consider the case, my lord.
Well, twice orders are made, but they have not done anything.
Your lordship,
Again, you want one more order?
Yes, my lord.
How that will help you?
They consider your lordship have complied.
You take notice for that, my lord. Many times he should come before the court. You fix time in disposal. In contempt, instead of enforcing, again giving time. Unheard of in any contempt book.
No. My small prayer of lordship's permission, my lord. There is a vacancy, my lord. They have considered, my lord, basing upon the Annexure 3, my lord. They consider.
Consideration.
Yes, my lord, consider, my lord.
Petition prayer reads as that. Counsel for the petitioner draws attention of the court to the representation dated.
My lord, Annexure 4.
Annexure 4. Which shortly reads as that. Next paragraph. Next paragraph. Counsel for the petitioner submits that. Though he was before this court in an earlier round of litigation, that is in WP number.
My lord, 15976 of 19.
15976.
15976 of 19.
Disposed of by a coordinate bench of this court by order dated 10/11/2023, and also a consequent contempt. What you call contact?
Contempt petition. CONT is number.
Contact number
103 of 24.
Disposed of by order dated 22/1/2020. First time he submits that even with this development, nothing has been done in the matter, and therefore one more direction may be issued, so that at least now they will wake up and take a decision. First, there is some logic in this submission. And learned ASC appearing for the OPs also agrees with the same. Next paragraph. In the above circumstances, petition is disposed of directing. Which OP?
OP number 2, my lord.
OP number 2 to consider the subject representation of petitioner within an outer limit of 8 weeks, and also inform results of such consideration to him, failing which heavy costs may be levied in the next round of litigation. All contentions dropped.
Connected cases are same.
Same. Representation same rate.
On Annexure 4, my lord.
Yes.
Date. Same date.
Same date.
Item 66.
May I please, Lord? Lordship, can come to page 37, Annexure 10. The government, this higher education department specifically instructed that there shall be no deduction from the from the salary of the petitioners or the employees.
They can deduct it from the institution if at all they want to.
But the government decided that there shall be no deduction. Thereafter, the director under Annexure 5 has issued an instruction to all the principals that to deduct. And accordingly, under Annexure 15, from my salary, 6 lakh some odds has been directed for reduction. But it is specific case of the instruction of
any instruction, any opportunity that feeling was given to you?
No.
Why, brother? Why deduction?
But that
government says no.
That the
He is
management,
more loyal than the king.
that management has been deducted, madam. Opinion number 5.
Correct. But why?
That management is the aided educational institutions management.
Issue emergent notice. The net counsel for the petitioner draws attention. Have you filed any application?
No, I was before this Hon'Ble Court in earlier occasion.
Now, for interim order, have you sought for any interim?
Yes.
Where is that?
I is there.
IN number?
IN number 2278928.
786.
726.
Attention of the court by IN number 5. So support by affidavit seeking interim protection. First, it draws attention of the court also to the government order dated,
my lord, that is 5/11/2022.
5/11/2022, which on perusal gives an impression that no deduction should be made. The case is made out for granting the interim protection. First, in the above circumstances, application having been favored, the impugned order dated
15, Annex 15, that is page 52.
6th December 2025.
6/12/2025.
Suppose if you take that money and go away, tomorrow, tomorrow your case is dismissed. How to take back that money? Therefore, that I will stay subject to condition that you will give a bank guarantee for that.
Now the petitioner at the age of, so there is no question of at the age of 48 million. Another 12 years are there to go for retirement. So there is no question.
So you may resign and go.
I mean, a approved employee. There is no occasion for me to for any
50% let them. 50% amount let them. So stay up for 50% first. I think in favor. The subject impugned order is stayed. The impugned order is stayed, subject to the condition that 50% of the amount can be withheld during the pendency or until further on.
Item 67.
Working as a Hindi teacher since 2010 in an aided institution. Though other employee have already got the benefit, but the appointment of the petitioner has not been approved, for which he approached the court, this court in earlier occasion, Annexure 6, and he will also directed to consider his case. And thereafter, he also kindly see Annexure 7, page 30. State government, referring to the earlier writ petition, directed the DO, basing on 2 government resolutions, that why the petition service has not been approved. Page 31 is the operative person. As it reveals that the petitioner has acquired the bachelor's degree and from Utkal University during 97 and Shastri from Odisha Rashtrabhasha Parishad Puri during 2001. It is therefore requested. Because the OP number 3 now is the authority to approve my service. Lordship direct to OP number 3 to consider basing on Annex of 7, my lord. Because government already directed to, he has the requisite qualification, why the person appointment has not been approved.
Short grievance of the petitioner is as to non-consideration of the representation dated.
Representation, I have last representation dated, I have given my lord.
28/7.
Annexure 95. Also refer my prayer portion because I have mentioned everything. Prayer portion I have mentioned.
Counsel for the petitioner draws attention of the court to the latest representation dated
28/7/2025. Annexure 9.
That's the 9. and says that if a direction is issued to consider the subject representation.
But that representation I made before the government. Now the OP number 3 is to take a decision.
You make
Press.
Reply to this. Learned ASC appearing for the OP submits that the representation has to be made to OP number 3. And if one is made, there will be no difficulty for considering the same if all contentions are kept to.
You think in view Annex 7 that government letter.
This is where what circumstances petition is poured off, giving liberty to the petitioner to make an appropriate representation to OP number 3 within 2 weeks. And if one is made, the same shall be heard and decided, which shall be considered within an outer limit of 6 weeks next following. All contentions are open to soliciting proportion.
Only I pray Annex 7 to be taken to account. Government letter.
Yes. Keeping you. The government letter number 2746 Assembly 9/2/2024. The copy whereof Pavel Sector Person.
Item 68.
I mean, video VC minor.
Yes.
The petitioner is paying for his pension minor. He is serving more than 10 years of service, and his service has been approved by Annex 6 minor. More than 10 years of service, he is paying for pension under Odisha Added Educational Nutrition Retirement Benefit Rule 1981. While he was in serving, the school was derecognized. Thereafter, he is not in service. Therefore, in view of the rule minor, Rule 4, Rule 5 of the Odisha Added Educational Retirement Benefit Rule 1981, he is entitled for pension. Then his representation under Annex 7 is pending, my lord.
Let them consider the representation.
Yes, my lord.
Will it be all right?
Yes, my lord.
Petition prayer reads as that counsel for the petitioner draws attention of his client's representation dated 18/10/2024, wherein the last paragraph reads as that. First, next paragraph. Counsel for the petitioner submits that if a direction is issued for considering the subject representation, the client will be satisfied. First, learned ASC appearing for the OPs agrees with this proposal, subject to the caveat that all contention should be kept open and a reasonable timeline be prescribed. First, very enough. 8 weeks. Open to solid.
But taking the consideration of the Rule 4 of the pension rule, 81.
Pardon, Sweetla, it will happen.
Yes, ma'am. Yes, ma'am.
The rules of yes. Next.
Item 69.
May I please note? Here the dispute is over. Plus entitlement to GIA plus to the post of plus laboratory attendant admission second post plus as per 1994 GIA plus the first dispute plus went to the tribunal at the instance of one Moester Satpathy, mindless at a glance, plus annexed to no, my innocuous prayer is plus. So if in the tribunal I lost the dispute clause. Thereafter I preferred FAO. In the FAO clause, my last glance, Annex 12, page 71. Page 71 clause. This honored court clause, may I place clause. Having heard Land Council appearing for the parties, in view of the fact that respondent 4 means Moester Satpathy.
Take a decision on the claim of the appellant for his approval as against post.
Yes.
Which has fallen vacant.
Yes, and then since they didn't act upon this clause, I preferred another writ petition, clause Annexes 14. Annexes 14, page 74, and the operating party is clause page 77, paragraph 4. Mr. Lionel Counsel for petition submits that through highlighting his grievances.
Nothing has been done in the matter despite all.
Yes, this representation, my lord, in this representation, I refer to a joint inquiry report of Regional Director of Education. Because they didn't consider.
You mean to say without hearing the other side, I should allow the
I have a unique prayer to reconsider my case in terms of the joint inquiry without expressing any opinion on the merit of the matter. This is my grievance.
There is a detailed rejection order at page.
Rejection order.
Rejection order, my lord. In that, my lord, the joint inquiry report that is which goes in my favor.
Let him take notice, file a short objection, because there is already an order. Otherwise, if there was no order, I would have perhaps I agree with your proposal.
Minister,
But let me issue urgent notice. Learned ASC is requested to accept notice for OP numbers. Which OP?
Except 5 all open parties.
Urgent notice to file. Matter lays in a narrow compass, and it is a third round of litigation. First, therefore, post in the second week of February 2026. Okay.
Item 70.
Yeah.
Item 70.
LLM3 semester examination. When it is?
But it is 2025. But perhaps he is appearing in person. He is appearing in person.
But in person.
There is existing Baramapur University, madam. That's
the examination matter, na?
That's
Pass on.
yes, madam.
Yes.
Item 71.
No, Chiva.
71.
More betting lines. What is it?
Take notice.
For the petitioner is not there, my lord. Let's make direct for that note.
G, issue urgent notice. Permit AG, the G accepts notice for OP numbers. Go to first stage.
276, sorry.
Or OPs. No, 1 to 4. Emergent notice to 5 ends. Okay.
Item 72 has been disposed of. Item 73.
Milords, I'm sorry, Milords, I'm appearing virtually, Milords. Milords, Annexure 3, Milords, will see the work completion certificate. Now what they have done, they have on the basis of audit para, they have asked me to submit securities and not releasing my securities. My Annexure 9 is pending, Milords. That can be considered in a time-bound manner. It will solve all my purpose, Milords.
Petition player reads as that. Doesn't it?
My lord, can I submit few lines?
Consider that.
Yes, my lord, it's a representation.
Correct.
So if your lordship will adjudicate the dispute.
I will not adjudicate. I tell you to adjudicate.
That is a.
I say that I will not take a decision on the representation.
All right. That's it.
Petition prayer reads as under. Learned counsel for the petitioner draw attention of the court to the representation dated good one is that
9.
6/11/2025.
6/11/2025.
11/25. A copy whereof awaits at Annexure 9, wherein he has raised a grievance as to withholding of certain bills, despite accomplishment of the working question. First, therefore, counsel for the petitioner says that a direction be issued to consider the subject of the grievance as has been aired in the representation in a time point. First, next paragraph. Learned AGA, on request appearing for the OPs, opposes the petition contending that matter is a civil dispute which may involve adjudication of some facts, and therefore petitioner should be relegated to other usual remedies like suit. First, having so contended, now he fairly agrees to instruct OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation, if all contentions are kept open, and if a reasonable time is prescribed. First, 8 weeks. Open to solicit information, that's it.
Item 74.
74.
Please, Your Lordship.
In these matters, ordinarily, I would have said go to civil court.
Yes.
But
It's a
why they withhold money is also known to the court.
My lord.
There may be good cases.
Yes.
Millers,
There are-
this is an audit objection, Millers. Basically, it's an audit objection, not a deduction, Millers. It's an audit objection. And audit has nothing to do with my works contract.
Next.
Millers.
Please, Your Lordship. Your Lordship, the matter relates to the wrong recording of the name of the father of the petitioner in his HSC certificate. There is a representation pending under Annexure 3, page number 9.
Page 9.
The 3.
Yes, Your Lordship.
Lecture 3, page 9.
Mr. Rao.
Yes.
Take addition on the representation.
For 1987, the HSC examination passed. And in 2025, that representation is given, that is only on last day of the November. So if you also give a direction to dispose of the representation, there will be pressure, unnecessary pressure on the authority. Your lordship is keep it to some other day, I will take instructions, what are that.
Mr. Rao, on request accepts notice for OP number. Follow this.
4.
Number of secondary.
3 and 4.
3 and OP number 3 and 4. Mr. G accepts notice what follows. First, matter lies in a very narrow path and therefore post it in second week of January 2026. In the meanwhile, or counter if any may be filed. First, it is open to the jurisdictional office to take a decision on the subject representation in the meanwhile, if they sold. Meanwhile, and pendency of the petition shall not come in the way of that.
You must make it third week. The second week is
third week of
November.
No.
Item 75.
Should next.
Your Lordship, you are agreed by the impugned order at Annexure 15, Your Lordships. But before I take Your Lordship, may I only place certain facts, my lord. But here is the case, my lord, where I got a provisional NOC from NHAI for making a petrol pump, my lord. I got the provisional NOC in 24. That NOC was extended in 25. Then I got an NOC from collector. Then I got the explosive license.
Take notice.
My lord,
My lord, I beg to appear on behalf of the opposite party.
You need not beg. It is your right. Yes. You take notice. Are you panel counsel?
No. I have been. I'm appearing on behalf of IOC.
Who are you? Panel counsel or what?
Not the panel counsel.
Yes.
I go Wakalat.
Wakalat. Issue notice. Learned AGA, learned counsel appears for OP number 2.
Opposite party number 1.
OP number 1. For National Highways Authority of India, who usually.
Amitabh Das usually.
I'll take notice, my lord, if Your Lordship says I'll take. So,
OP number 2. In addition to taking usual steps, counsel for the petitioner is permitted to serve a copy of the petition on the panel who usually represents the said vote.
I've got an IA, my lord, but I'll not burden Your Lordship.
IA shall be considered after.
Sir, may I only place, my lord, a short time period? I've already invested a huge amount of money, my lord.
No, I said I will consider after notice.
Yes, deeply.
Service of.
I'm only saying, my lord, a short date may be fixed, my lord, right?
No date can be fixed. Service of notice.
Deeply obliged. I'll do so. Grateful.
Item 76 has been disposed of. Item 77.
May I please, Your Lordship? His petitioner is a Khansama. Simple prayer is paid still attached to that poor is not getting. For that, he made a representation that is Annexure 10 is pending. And the remainder is Annexure 11, Your Lordship. In your case, Your Lordship, direction be given to opposite party number 1 for disposal of my representation. They have received it, that is also I have the attached that receipt. And in the Annexure 10.
You take notice, I'll call this in the second week of January.
My lord.
Issue emergent notice. Go to cost title. AGA is requested to AGA is requested to accept notice for 3 and 4. Matter lies in a narrow compass and therefore post it immediately after service.
Item 78.
May I please, my lord? My lord, the petitioner is the principal of the institution appointed by the Annexure 5, your lordship. My lord, the institution has been declared as a composite institution, composite college, because in the state there are two kinds of colleges.
Two classes of college.
My lord. One is degree college, one is junior college. There are colleges.
Junior college means?
Plus to 11th and 12th.
In addition to 8th, 9th, 10th?
Might not be. Might not be. Standalone.
In some institutions, it is
Standalone also.
Yeah.
in some institutions it is combined. In some cases, it is
They are different. This institution has been declared as a composite institution by this honorable court and has been affirmed by the esteemed apex court, your lordship.
issue notice in these cases so that
Maybe questions of notice for.
My lord,
Numbers
1 to 3. Government to 1 to 3.
3. Emergent notice to 4.
My lord, stay operation on 16 is warranted.
No, what is the consequence? We will consider application after service of notice.
Right.
Application IA to be considered immediately after service. Oh.
Item 79.
Please, madam. Your Honor, petitioner was appointed as a lecturer in history on 9th of December 1993. Lorraine Tribunal, my lord, passed a judgment on 6th of February 2010 declaring that petitioner eligibility that from 1993, my lord. My lord, that was challenged by the state government by filing a FAO that was dismissed on 20th of February 2024. Again, state government filed an SLP that was also dismissed, my lord. Till date, my lord, I'm not getting that benefit in spite of the judgment of 2010, my lord.
Issue emergent notice. AGA requested to accept notice for. Put the question. 196. Emergent notice to be. Yes.
My lord, since director is in the session of the matter, if short
Item 80.
It is similar to yesterday by item 85. I also.
Yesterday 85. Tell me back. How I will know yesterday's out.
Yesterday yesterday 85 and this matter was tagged to 85. Yesterday was not yet been uploaded.
Same order.
My lord, sir. Correct.
Follow.
Item 81 has been disposed of. Item 82.
82, my lord, this is covered by Loknath Bera case, lordship first.
Both the matters.
Both the matter. I have corrected, my lord.
You have corrected.
My lord.
But 3 orders you are doing.
Wrong. I have not corrected.
Fair one. You have done the fair one also. No, let them do.
Item 83.
The non-compliance of the order passed by this honorable court filed annexure 1 of the content petition, my lord.
What was the order?
Considering the reference of the petitioner within 8 weeks, my lord.
8 weeks expired when?
Expired on. I order comply, my lord, the order to the filed annexure 2 series. The received.
Order was passed on 5/8/2025. It was lordship directed to dispose of the representation within 8 weeks. So, in the month.
Police notice to office. Alleged contemners. What they are called in your contempt rules?
Contemners.
Contemners.
Proposed contemners.
Proposed contemners. Issue notice, police notice. What kind of person is? No, contemners. Yes. Returnable within 3 weeks.
Item 85.
May I please, your lordship?
Yes.
Lordship, this case belongs to the petitioner prays for reconstruction. My lord.
issue police notice to this contempt. They may be required to appear before the court in the next level of proceedings. If first, however, such appearance may not be necessary if in the meanwhile the decision is taken as directed by this party. Similar matter in all contempt matters have this format. Yes.
Item 84. Lord, in this case, the petitioners pray for the reconstruction of the file pending before the member board of revenue.
It is lost now.
Yes, my lord.
Yes, notice, let us see what they will.
My lord, already notice has been issued by the order dated 21/2/2025. They require just a formal order for reconstruction, my lord.
No, it is not.
The notice was not issued.
Yes, yes.
Instruction. Instruction to be obtained from the concerned authorities. Notice was not issued.
This has to be issued, na?
Yeah.
Go to the cost. Construction of a file is a serious matter. It is not that simple. Because once it is rebuilt, all they become original records,
Yes,
which you
madam.
can mortgage and other things. Many questions will arise. And in the meanwhile, the original documents are found. And they are pledged elsewhere.
Yes.
The priority, so many consequences. There is one famous judgment by Madras High Court by Justice Rajamanna.
My lord, kindly have a glance to annexure 3, my lord, page 16.
It issued emergent notice, returnable within 3 weeks. No.
Item 85.
List.
Yes, sir. Mr. How is your health now?
Yes, sir.
No problem. Can go on.
But I'm able to actually present the matter.
No, our presumption is when health is not good and still the counsel appear, presumption is that he is heavily given good attracting fees. Yes.
Well, this is a matter you also kindly appreciate that Vedanta had 2 plants, one in Jharsuguda and one in Lanjigarh. MCL used to supply coal. University knows after nationalization of the coal, there was some shortage of supply of coal to public sector undertakings, because they are giving priority to the government sectors. So therefore, due to shortage of coal, some PILs were also filed, because the plants are getting affected, as a result of which the cascading effect of the MSMI units were also there. So Honorable High Court, this Honorable Court directed, sit together and finalize the matter. So there was a joint meeting. The joint meeting which was held, that in road actually we cannot do it, in rail we cannot give, you can take by road. And therefore there was an understanding between them as per the CIL's notification. And then MCL issued a notice that you surrender so far as that railway supply is concerned, you exercise the option to get by road. We exercise the option. So they gave a serial names were given, our plant also given the name, that will be given supply by road. Then they fix a particular amount of percentage on per racks, what is to be charged. We accepted. Supply was made, money has been paid. 9 months after, they filed debit notes saying that the amount of percentage we have fixed is not correct. That's an inadvertent mistake, and you have to pay 36 crores and more than that, the differential amount.
If it is true,
well,
if that is true,
no, that is not due.
Arithmetic calculations that
we have already paid the entire amount which was claimed, and the matter was closed.
What was the rate fixed?
Rate 2.55 per X percentage.
How much amount it would be according to you?
So the entire amount has been paid.
No, that too, it's a matter of, you take notice. Yes. Emergent notice you take. Okay, issue emergent notice. Learned counsel Sri. So appears for your briefing of justice. Issue emergent notice. First, learned senior advocate Mr. Shah presses interim prayer. First, the interim prayer shall be considered immediately after service. Okay.
Item 86.
Right.
I am in VC, my lord. The petitioner land has not been acquired by the state authority or municipal authorities, my lord. But to the behest of the private parties, my lord, the authorities have directed by the impugn order to remove the structure which she has constructed on her own land, my lord.
No, whether it is on her own land or not, how this court should decide.
Well, they have decided that to remove the structure, that non-maintainable person, my lord, under 133 CRPC, because there is no public nuisance on his own land, my lord, private land. They have directed the remove. Your lordship may issue notice, my lord, let them come.
Go to pay the DG requested to accept notice for OP number 1 and 2.
1 and 2, my lord.
1 and 2. 1, 2, 3, 4, my lord. Private. No. State of 1, 2, and 4.
2 and 4. 2 and 4. Then notice to the rest. Post immediately after service. What?
My lord, can I place my miscase, my lord? I have miscase. In the meantime, her should not be given effect to that order.
To maintain status quo. Till next. I'll come back. Yes, Krishna will come back.
Up to 2 minutes.
Item 87.
Yes, madam. For RSC case, madam.
Covered by judgment.
Yes, madam.
Before put on the floor. Put away, so Bismisha.
G.
My lord. Which covered it is? Saraswati?
No, that Ashok Kumar, na?
Ashok Kumar Mahapatra.
Yes.
Item 88.
I am filing the amendment application. Consolidated REIT application.
You have to file the application in the registry. Give that back.
You file it registry.
You have to file in the registry. They will verify whether affidavit is there or not, whether it is in the format or not. We cannot turn it off that. Counsel for petitioners is trying to file application for amendment. First, permission granted. Okay. You file application. Yes.
Item 89.
My lord, I am for the petitioner. Lord, may I renew my prayer for a short adjournment, my lord. I am a little more preparation is required, my lord. I am not prepared.
My lord friend has already told me. I said that I am a hard person, so I cannot say anything my friend will say. But I say I have filed petition for vacation also because challenging the award by the MSMED. So
immediately
after vacation.
Post this matter immediately after vacation at the request of both
the IE. Both the areas. One application for the deposit.
I to automatically will be attached to the deposit.
Yes, next.
Item 90.
What's okay?
I have given the petition for vacation of I was university.
From the university.
Man, in this case, your lordship, the guest faculty issue. Guest faculty issue, your lordship. In the end, your lordship.
You inform Mr. Mishra that I have passed.
My lord, in this case, my lord, your lordship is specifically your lordship has given the judgment in this aspect. Saying that guest faculty doesn't have a right to continue, your lordship.
Give them.
Yes,
has to look into that judgment.
Yes, yes.
Justice Manigraya.
Yes, my lord, my lord. You are referring all the judgment, my lord, which he has relied, giving all the.
Mr. Bose, look into that.
Yes, your lordship. Because the date expires on 31st December. And your lordship has allowed the interview to go ahead with the interview.
Yes, your lordship. Yes, your lordship. Your lordship.
If you completed, you cannot have.
Your lordship.
Again, litigation will come.
Your lordship has granted that petitioners shall not be disturbed. All the process will continue and they can appoint any other person.
But the term
petitioners will not be disturbed.
But the term expired on 31st December, my lord.
When term expires?
Yes, the term expires and except 5 year lordship may kindly see page 27.
My lord, it has been given on 11/6/25 and it will continue for 1 year. Your lordship, or fresh selection till regular faculty is appointed. So June is the date of my completion.
Then what he says is, it is given subject to, you have accepted it subject to this condition.
No, my lord, not this. This was on 11/6/2025.
Correct.
The interim order was passed thereafter.
That's all right.
Yes.
We passed the interim order. See, generally on our version, we passed
Yes.
the interim order.
Your
What is
lordship.
your right to continue? You are appointed to facilitate regular recruitment.
Yes, my lord, it is not regular. This is also temporary appointment. Let them say it is a regular, I will withdraw my case.
My lord, your lordship, that aspect has been dealt by this honorable court.
So that we see.
Yes, your lordship, that aspect also, because your lordship, we have to take fresh selection with that. He is also participated there. He is also he also taken an interview. In the interview, he is apprehending that he may not be selected. He is apprehending that he may not be selected. So the advertisement has to be passed. That aspect we have decided next week, your lordship, because the expiry, the date expired on.
My learned senior will allow, I'll just.
What expiry?
Your lordship, that term expired on the 31st December.
It is because of the court order.
Yes, no. The
is not expired.
Your lordship allows till the petition is disposed of. Your lordship allows them to continue till this petition is disposed of. Your lordship order.
Correct.
Yes, your lordship. And
now, just I am asking you.
Yes, ma'am.
You want to substitute one set of the people by another?
Another temporary.
My lord, we have it is an academic arrangement. Your lordship, that has been dealt by the judgment. It is academic arrangement. The better candidate will feel great. And if you doesn't qualify the UGC guideline, why should you continue? They are to be continued. That are aspect also you have to examine. Better candidate, better teacher. Why will not be the student get the facility?
Okay.
Why?
The second week of January 2025. So that court will answer the question which Council for the University is now posing to it. What?
Interim order to continue.
Interim order to continue.
91 is also same well.
Your lordship, second week of.
Your
lordship, fix the date, your lordship.
No. Next.
Item 92.
Into that. Your
lordship, 271, the weekly list also same, my lord.
271.
What, my lord? Same thing.
Interim order to continue that.
Same thing, my lord.
Correction. All may be tagged together, my lord.
Yes, called together. Only one correction is, it's my mistake, my lord. While preparing the read petition in the first title, the place of posting I have mentioned wrongly. Only that. At least you filed an application. So that yes, I have filed an application. You filed that? Yes. Before notice or after notice this is?
But this has been allowed, my lord.
Dispose of case.
Petition has been allowed. Matter is to transfer, my lord.
Matter relating to transfer. That is by the MP and the MLS, and your lordship was pleased to dispose it of by referring your lordship's judgment. But in the first title, I have wrongly mentioned the place of posting of the petition. That's I beg your lordship's counsel for the petitioner has filed an application to seeking a changed place of posting. The changed place of posting, namely Gopabandhu Memorial High School.
At post Danta Mukundapur.
At post Mukundapur.
Yes, Pipili
District Puri. Instead of
Biro Hare Krishnapur Nodal High School.
So council submits that the mistake was by inadvertence, and therefore he should be permitted to have the same rectified at the heads of the school. This court, in exercise of its power, ex dubito justitiae, allows the application and registry to rectify, registry to change, registry to effect change as sought for in the subject application and issue a fresh one if applied.
Item 93.
Item 93, I am on BC. I am appearing for opposite party university. Can it taken up after lunch? I will be appearing physically.
Well, you can argue now, no problem. I am hearing your voice.
Only no problem. Yes.
Yes. What is this matter? Cashment? What GPF pension? Take notice, Mr. G. Pension.
Already I filed counter.
I
am appealing for university minor.
Parties contesting of.
We will consider this after vacation.
Yes, ma'am.
Call first week of February 2022. Yes.
My appearance, I am appearing for University of 3 and 4, Vice Chancellor and Registrar. Odisha University of Agriculture Technology.
Okay.
My lord, item 94 will file counter in this case.
My lord, here that is covered under the Rajiv Sahu case, lordship, that is ISP in SC department. Notice was issued.
But there is quashing of order. That is
Here also it is quashing of order. Lordship, have a glass.
that is why I want to file counter.
It wants to file counter. Let him file within 2 weeks. Counter to be filed in 2 weeks. Call it the second week of January 2026. Or third week of January 2026. Yes.
Item 95.
My lords, item 95, that is stay order. They have filed counter, but I need little instructions.
Well,
That is why.
the difficulty is that the petitioner is going to retire on 31st January 2026.
So before that,
He has to submit his pension paper. In the said prayer, my lord, they have reduced the pay of the petitioner and directed for recovery. Your lordship has given the interim order so far the recovery part is concerned. So she could not file her pension paper prior to 1 month of his retirement.
Now that 1 month will be extra. It will be 1 month.
So they have filed the counter, they have admitted the fact.
Wants to come with some preparation. I am also not taking a final disposal matter because of this.
It will be taken up first week of January. Because she has to submit.
Can do it.
She has to submit her pension paper. My lord. They are forcing the petitioner to submit the pension paper since they have 1 month left for your retirement. So
First week of January.
Item 96.
Your lordship, sorry, due to wrongful termination, deprived for area salary, and your lordship already allowed that man by passing that rejection order. Your lordship already allowed man. The petitioner was appointed under rehabilitation assistance rule. Subsequently, due to abolition of NFP, he was terminated. Again, government readjusted. So only that period has to be taken into account, man. Because due to fault of the government, why the party petitioner will suffer, man. Because he was appointed under the rehabilitation assistance rule, man. Under Annex 19 series is the rejection order, man.
Very same order is questioned.
Yes.
Different order.
Different order. Here, in that case, Annex 7.
Mr. G, look into that.
My lord, in the self-same matter, my lord, this matter was before your lordships in the case of SK Hota, na, ita to pore SK Hota case. SK Hota went to Supreme Court. Matter was remanded back to this honorable court. This honorable court disposed of by giving a positive direction in favor of the petitioner. And basing on which all the orders were passed by all lordships.
Then it's covered by the judgment.
Has also passed this order.
This order was also passed.
Only that addition is the interest part is 1%.
Interest
that interest part cannot be there.
Cannot be there, only that rejection request in that period has to be.
Then that I will grant, but they are saying if you want interest, then the matter needs to be heard.
Only 1%, my lords. That may be waived. I think
per month it will be 10%.
From the date 7th of 2003.
Only annexure is different.
No, that's all right. That I will do.
Yes.
But if you agree to give up as they are suggesting, others will hear the matter and it will come in the February, March, April, May, June, July.
Only interest part may be deleted.
You file just memo. The subject matter of this petition is substantially similar to the one in WPC number 17436 of Vijay Ketan and others disposed of by this court by the order dated 26/11/2025. First, the operative portion of the order reads as under. Next paragraph.
Remand matter was heard by Chief Justice Wadhela.
Learned counsel for the petitioner graciously agrees to give up the interest portion, the claim for interest portion. First, this is appreciable. Next paragraph. In the above circumstances, this petition is disposed of, granting the same relief as has been accorded to cognate in the cognate case. Yes, this. All right. But the report to be compliance report to be filed with the Registrar General will remain. If they don't do, then move contempt. You will get even that part.
That Annexure 19 has to be passed.
Yes.
Next, if Annexure 7, but here is Annexure 19. Here in this case, Annexure 19. That has to be passed.
19 to be questioned.
Yes.
Nothing. They are sitting in the district education offices. They will get it done.
And another matter that has not been listed, same issue, so can you list next to you also?
Let us see. Next.
Yes. Item 97.
May I please, Your Lordship?
But my case stands on a very small pedestal.
My lord, it's in 97, we have filed the counter.
Yes, counter rejoinder, everything has been filed.
Yeah.
Very short point is involved. Very short point is involved.
After vacation.
My lord,
Immediately after.
the appointment matter. My lord, may I suggest, my lord, I will take only 5 minutes.
No, but there are many matters for me. You will take only 5 minutes, perhaps 4.5 minutes. But I am not as fast as you. In the first week of January.
In the first week of January.
Next.
Item 98.
This matter is covered by the Loknath Behr. I have corrected also.
All the three matters.
I have corrected.
Yes.
Item 99.
99, Lordship, my case is on a similar footing with your Lordship's order, the copy of which I had given last time, I had handed over. Shri Anand Kumar Naik in WPC 23919. When he was.
There is similar case. Your Lordship.
Yes.
One more time. You were not seen in the court hall for about.
No, my lords, on the
not well or what?
No, my nonagenarian mother is ill.
Learned counsel for the petitioner submits and learned senior panel counsel appearing for the OPs does not much dispute that the subject matter of this petition is substantially similar to the one in WPC number 23919 of 2023 between Ananta Kumar Nayak versus Registrar Utkal University and others. Wherein the operative portion of the order reads as under. Counsel for the petitioner submits that similar order needs to be issued in this matter as well on the principle of verity as held by the apex court in a series of decisions, there being no repugnant factor or treating it otherwise. First, there is force in this submission. Next one. In the above circumstances, the petition is disposed of, granting same relief as is being granted in the cognate petition, mutatis mutandis.
For your lordship's information, that was the reason why I have not filed the counters.
No, in covered matter, what counter?
Malums.
Yeah.
Obliged.
Item 100.
May I please, your lordship?
Yes, Mr.
We are licensed photographers, my lord. Our license are to be renewed. Your lordship, as per your lordship direction, we have served copies on the other side.
Who appears for the other side?
I am opening for open numbers 1, 2, and 3 on behalf of the DSGA. But I have sought for instruction. They have yet to be received that.
What did to be received?
My lord, this is
They are
archaeological
applying for-
society.
It is not application for fresh grant. Supreme Court differentiated between grant of license and renewal of license. In grant of license, we have abundant discretion. In renewal, we have no such much discretion. You should have considered their application for renewal. Till you take a decision, permit them to operate.
No, sir, Lordship knows my predicament. I cannot insist on anything without any instructions from the authority.
No, I'll record that they are not giving any instruction to you.
No, sir, Lordship, I have given them email and other correspondence.
Correct, you have done your duty. They are not doing their duty. And you have done your duty. I will do my duty.
The only fact is that a contempt petition is pending with the self-stamp prayer minutes in the end.
We have one here.
Contempt enforcement is one another thing. That now either you take a decision within 1 week or permit them to work as if their license is till you take a decision. Option is
That
first.
is some reasonable time after vacation.
That is what the honorable, for 1 month, Konark is going in a chaotic stage, your lordship. We are the only licensed photographers, as per the act, my lord.
Any application is filed.
Yes, yes. That is the Annexure 1 series, along with the amount deposited, your lordship.
What was the order?
Order in the?
Any order was made earlier?
It is
that contempt matter is pending.
Contempt is pending. That is also pending, your lordship. We won there. There we are the only persons who can operate. That is in our favor, not the other persons. We 8 or 9. We are authorized to be the photographers in Konark temple.
By the order.
By the order. That they are not. They are allowing others to enter.
So where is the order which says others should not enter?
That is the subject matter of, my lord.
Contempt.
Contempt. Read petition in fact. That is already there.
That order. Another I in that contempt, which is some prayer and they return. That is what
Contempt is enforcement. It's the prayer.
Also the record of the contempt also, but
My lord, why this delay upon his part? I don't understand. Konark temple is going without a licensed photographers. Contempt again. Check by Sat Your lordship may have a look to this.
Report. This is 101 is also yours, sir.
No, sir, 100. Your lordship may have a look at this order, which is the subject matter of contempt.
The coordinate bench has passed this order.
My lord?
Coordinate bench this order.
Yes, your lordship. Justice Sinha's order, my lord. 300, 200 odd people, they had entered into, my lord, entering into this premises.
Have you sought for any? You also sought for any interim order?
Yes, we have filed an IA, they have ever concerns.
We have filed in that contempt.
Para 7.
But in this, you have not filed any application.
I have filed an IA, my lord.
Where is that?
I know better this.
That is the average para 7, 444 of 2023.
444. That is in contempt. In this case, my lord, 22893 I.
22893.
My lord. Scanned copy must be there.
That I is unfortunately not part of our record file.
Have you served a copy on the other side?
Copy has been served.
Because I'm serving an extra copy.
I've got the copyright of it.
Extra copy.
Whether it was served on him before?
Yes,
Everything was served on the DSG office.
On your office it is served.
Lord, I have to cross check them. It's not a part of the file.
No, how to disbelieve your brother?
Lord, I am not.
The receipt is there.
Cross check something.
Lord, I have to.
Whether in our records, services evident that they had to find the application in the office of the DST, then they have filed this family. Look into that.
So I filed on 18th December. So afterwards, no receipt is available.
No receipt is available.
Receipt is there in record, my lord.
Just looking. That is the receipt.
There is a noting also.
Noting is there. Yes, your office is heard. If your office does not have good
This is the memorandum, sir.
with you, we can heard of it. I don't make this to how many petitioners there?
Except 8, sir.
He submits that the subject matter of the petition is substantially similar to the one in WPC 25176 of 2021 between Akshay Kumar Malik and others versus Union of India and others. Third and disposed of the coordinate bench of this court by order dating 5/1/2022, and therefore similarly needs to be granted to these lines also. First, CGC. Are you CGC? Next paragraph. In the para 7 of the said order, relief has been granted to the litigant therein with the following observations. Para 7. Mr. Sarang is submitting that the similar case of his client should be treated on par with the case in Akshay Malik on the principle of varied. Learned CGC appearing for the OPs submits that though he had sent intimation to his friends, there is no response from them, and therefore his hands are tied. First, when official OPs do not respond to their panel advocates, that cannot come in the way of worthy litigants getting justice at the hands of this court. First, however, main matter would be taken up as requested by the PGC of authority. In the meanwhile, the interim order as granted in Akshay Kumar Malik Subra on 29 August 2017, which reads as under, needs to be granted to the petitioners as well. That is para 6 from that version. Next, ordered accordingly and application is put on. Yes, madam, you are permitted to keep on through.
Item 101.
Time will be proper to submit, madam, some time.
From this matter in the first week of February.
No, this renewal part.
No, that comes after. No, you are granted. You can operate. There is some similar order. That order I have granted, which Honorable Justice Sinha had granted.
My lord.
That same relief I have granted to you.
With immediate
matter would be taken up.
With immediate effect.
This order is made today. I have never said that it will operate after 1 month. Yes.
Your Lordship, that I was listening to that speech of yours yesterday, it was one of the finest, my lord. The control, my lord, has with this all command rather on constitution and other things.
Just item 101, my lord. Your Lordship, last occasion
That matter,
directed.
my lords, require that is the government should come up with a place, my lords, to where the vacancy is, so that the person can be transferred to that nearby place and the honorable court be compliant.
I'm submitting, please.
First case is for contempt. Whether the authority has violated any contempt or not. There are other cases. In other cases, my lord take the decision. That
So far, my
whether
lords-
contempt is they have made out or
So far, my lord, the contempt petition is
Lordship, kindly bear with me for a moment. Your Lordship directed me to adjust that principal in a nearby school. So government has issued a letter seeking only a 2 weeks time so that locate the vacancy and give him posting so that the matter ends there.
No, if I will record your submission. Yes. You will give them a posting within 2
Posting
weeks.
within the Cuttack vicinity we shall give.
Then go over. Everything is over.
Everything over, my lords.
All matters are disposed of.
Yes, yes.
I have also filed on the IA 22913.
No, that your position will not be affected.
No, my position. The who is creating disturbance in the college, he is continuing since last 37 years. I have filed on the petition that first he
I'm
is
talking of Ashok Samantray.
he is
Ashok Samantray.
5 lakhs.
Now that another thing.
No, he transfer him to other college. I have also filed the IA. Because he has filed the written application. Because he is not affected in my way. He is not a party in this case or he is not posted in my place. He want to how to oust him and he will work in that post, my lord.
Now that question will not arise because he will be given posting elsewhere.
But so my
So over.
whole total purpose is and dispute is stop, my lord.
Because they are creating disturbance.
But even when he is posted to some other place.
Yes.
That then you should leave the post.
No, I will go. I have said I will go anywhere. I am not desired to work in that place because I humiliated in each day.
No, 1 second. Now we are shifting into some other place.
Yes.
You will be miles away from that. How you will be disturbed?
No, I will transfer to other places. I have prayed that after 5 months I will retire from service.
Now we have only 5 months.
5 months.
So which place you want?
In nearby place, I have already done it.
Saying I will reveal you.
That will solve the disputes.
No, arguing, my lord, main case is, my lord, they are creating a disturbance how to oust me from the college.
Don't worry about it.
Therefore, I have filed a petition.
Let us not go by sympathy and antipathy.
Since last 37 years.
We shall take care
I
of
have
everybody. Don't worry.
Only for 10 years I have worked.
We shall take care of everybody.
We are interested for the institution.
We are
Here is.
And he has misappropriated 40 lakhs rupees.
31/10/2025. Your Lordship has been passed an order.
There is no manager, the sub-collector is the president.
Therefore, you are only an employee there.
Yes, I have also, as per the government direction, I have intimated to all that these persons are misappropriated the government money.
Call this matter in the last week of February 2026, when court will get time to decide this matter. Yes.
My lord.
Sir, I have collected some vacancy position.
You are not, see how unreasonable you are. I'm sorry to say this. Learned AGA says they will protect you. And they will give a posting to you.
Yes.
Still you want to argue the matter, whether your client is behind.
No.
Why are you arguing that?
Because
they agree with your proposition.
Yes, I have
Kindly remind, 2 days before, my lord sir directed to take instruction after 2. We have taken instruction. They are taking and making the process also. It will take a reasonable time.
I am giving it
But no one is
All the petitions should be disposed of.
everything will be completed by this.
I have some vacancy nearby places.
Not necessary. We shall locate it. We shall locate it. It is.
They are saying they will give you posting in the nearby place.
Yes, I am giving that one nearby places of Bishop.
No, not at your age. Not at your age, sir.
It takes. If you are given nearby vacancy place, you will be happy.
Yes, I am not interested to work because in each day I am humiliated by the staff.
You are humiliating the judge now.
No. Therefore, I filed petition to transfer him also to that Mahadev.
This matter was argued by advocates appearing for the parties very vociferously other day and this day. First time. However, having argued, learned advocates appearing for the parties graciously agree with the suggestion of this court that who is your plaintiff?
Ashok Kumar Samantara.
Sir, which is that petition?
Petition WPC number 31119.
Petitioner Shri so and so in WPC 6011.
31199.
Last one.
31199. 31199 of 2025 should be given posting in a nearby school. College. In as much as he has to peacefully retire from the service within about 6 months or so.
5 months.
5 months, within about 5 months or so. First of all, with this proposal, learned advocates, the AGA, Mr. G is very graciously agreeable and assures the court that the said petitioner shall be given posting in the nearby college within 10 days. Within 2 weeks. Within 2 weeks. First of all, in view of the above, till 2 weeks, what he should do?
I'm working
there. He also agrees that till then the petitioner shall be permitted to work in the same college without any interference from anybody, subject to following the usual decision. Okay. Next one. In the above circumstances, all these cases are disposed of.
No, I've given that the vacancy person. My lord,
that you should be open to the right, to give the names of nearby colleges so that it becomes easy for the decision maker. First.
But in that case, the transfer order, they have without the, I have challenged that the who is passed the transfer, he is not the authority. Second,
therefore that order goes now.
No, he would quash that order. That improved order because they have given punishment till retirement. He will not be promoted.
I'm just doing it.
Who are you? Who in my case?
Yeah, just
no. See for the
kindly see the reaction from my
lawyer. See my in my case,
I can understand you being unreasonable to the court, but you should be reasonable to your brothers.
First one petition was filed by the petitioner challenging the same transfer order. That is order dated 23/10/2024, and that has been withdrawn by the petitioner. Again, another application, interim application has been filed by him that was come up before that court. Honorable Justice Biraj Sankar Satpathy on 30/10/2025. That IA has been dismissed. On the same day, a mention has been made before this court, so the matter was taken up 31/10/2025 in a special notice. And then without suppressing the entire facts, plus your lordship has pleased to, issue notice in that case. So the case has been, once has been dismissed, plus how the second division maintained. That is my point.
Now,
your lordship has a very good view.
The government, but what should happen to that order?
Yes,
that order has to go.
Yes, punishment order.
He will be put to injustice.
Yes.
The very idea to settle this matter is that there should be peace restored. Then the order by which he aggrieved, that has to go.
Look, that is there. One aspect, here 6 lady lectures have been. I should not. Only I am just making lordship aware of the fact because there are some.
Just a minute. Let us solve the purpose, my lords. All these order will suffice the purpose. Only one small prayer, my lords.
The order dated so and so.
Annexed 23/10/24.
24.
Annexed 6.
Now pales into insignificance.
23/10/14.
That's why it pales into insignificance. Instead of crashing, I am saying it will be filed. That's all. That order now goes because he will go out of the institution to another institution. Yes. Over. Your headache is over.
No, yes, boss. That part is. That they know.
Only small prayer matters, you will continue for 2 weeks till an order matters, transfer order comes matters. Let him not harass matters to.
No, he is saying you should not harass him.
No,
Exactly. Government orders are
No, so that the thing is that you will, because now continuous matters as a principal, there is every possibility I would be again put into troubles. A single line matters, single line matters means observe matters, that means suffice matters, let him not harass the.
That amount to say, let him stop taking bribes.
That exact what my lord says, I much so far the philosophy and proposition are the idea matters, I am not disputing.
To say that she should not harass, you have to make out a case of harassment.
That is another cause of harassment.
They tried again.
Heat observation.
He put me in a harassment.
Kindly take your seat. You have heard you enough. You have been granted full relief.
Yes.
Still you want to argue. If you argue more, then I will recall this order, post it in June, first week of 2026.
No, I have not done.
Then sit down. Do not disturb that way. Yes, and respect your brothers. You may not respect the court. You should be respectful, very respectful to your brothers, because each one is holding the brief for a particular client. They are not self-interested in this matter. If you say, who are you? Why are you arguing like you? It is for the court to ask those questions. Do not arrogate to yourself my powers. I have been appointed by the warrant of the president. I exercise that power. But if you have that warrant, kindly show me. Respect your power. It is open. If there is any issue between the petitioner in WPC 1999 or 2025 and who are you in that respondent? Which respondent?
Respondent matters.
In that WP, you are not the respondent.
No, WPC, my WPC is 2681.
And the petitioner in
WPC number 26812. 26812 2025.
2025. Appropriate relief can be had by moving appropriate proceedings before the appropriate authority. In that connection, all contentions are kept open.
All the cases may be disposed of.
But you ensure that his right is not put to problem. He is retiring within 5 minutes, 5 months. Yes.
18. 18.
Item 18.
Where is the petitioner? 14%.
It's not there.
Not here. No, that is a base.
No. This one. This 18.
Then we will call this matter after vacation. Mr. Behra.
My lords.
Because he is a party in person. If it were to be lawyer, I would have dismissed it with costs.
My lord.
The matter was taken up in the morning. And there was no appearance of the party, petitioner party. First up. Therefore, matter was passed over. First up. Mr. Behra draws attention of the court to the arguably illogical prayer made in the petition, and submit that such petition should not be entertained at all. There is some force in this submission. Next point. Now the matter is called out. Call out the party.
Kartika Chandrakant Sabat.
Matter is called out. And the name of the petitioner party in person is called out to loudly by the court officer or instruction of the court. First, there is no response. First, next, in view of the above, to call this matter in the third week of third week of January 2026. From you only. will be the party in person. Sorry. On 79. So
That is good.
Right, another. Item 70.
LLM
third semester, my lord.
when examination?
Yes, 22nd edition.
Huh?
22nd this month.
22nd of this month.
My lord.
But lady is not here.
Yes, my lord, he's not in person, my lord. He's a lawyer also, my lord.
He's a lawyer also?
Yes, my lord. That he has annexed the identity card of the bar association, my lord.
I'll call this matter on Tuesday. So that if there is any urgency. 22nd it is.
Yes, my lord.
Then there will be problem.
22nd. But it's Monday, my lord. Lawyer name. So Shriya Swati Suchita.
No, she wants to take up LLM examination.
LLM examination. He has deposited the cost because of his shortage of percentage. He is not allowed to, for that is a grievance.
No, you let her take examination. Subject to, and don't announce the result also.
Yes.
Who should allow that?
That Berhampur University, my lord. Opposite para to let's say register at PG Council.
Issue notice. Learned AG accepts ASC same accepts notice for one. Emergent notice to other
rest of the
OPs. First up. Any application is moved.
Yes, my lord.
Yes.
Interim application number 22674 of 2025. IN.
An application in IN number so and so is moved by petitioner party in person who is said to be a practicing lawyer, practicing advocate. First, in the said application, a request is, an interim prayer is made for permitting the petitioner to take up third semester examination of LLM.
Scheduled to be held
in the third week of this month. That is scheduled to be held on. You permit her to take the examination, but don't announce the result.
Free copy maybe.
Also, Sri Chuli requested to accept notice for 2-3-5, and he graciously accepts one first. Next, the application submitted by an activity seeking permission to appear in the LLM third semester LLM examination, scheduled to be held on 22nd of this month. First off, a perusal of the petition prima facie shows that petitioner is not permitted to appear because of arguable shortage of attendance. First off, that needs to be examined with deeply by this court after the other side finds its conduct. First off, justice of the case warrants that the petitioner should be permitted to take up the said examination, subject to the condition that the university may not announce the result thereof, and that petitioner shall not seek any equity on the basis of this interim. Let her take examination. Registry to deliver a free copy of this interim order to ASC and to the panel council appearing for the university.
My lords, item 18. Your lordship posted.
A copy of this petition may be sought to me by the
in the meanwhile, petitioner to serve on this matter in the third week of January 20.
My lords posted to 17th January,
17th.
Saturday, so that.
So it will be instead of 17th. That petitioner, that January 17th,
My lord.
16th you have to give that party in person. Okay. This matter we'll have in the last week of January.
That
yes, Mr. Chudi, Dr. Chudi.
Yes.
We'll have it in the last week of January. Then, in the meanwhile, petitioner to serve copy of the petition along with all the documents on the learned panel council.
Pardon to mention, Lordship.
Yes.
Weekly list 118. Relatively second week of January.
118. 118.
Yes.
What is the urgency?
I am not as second week of January, I am saying. Because
That will be because immediately after reopening only.
No, I mean second week.
Third week of January.
Yes.
Third week of. Yeah.
Item 48 would have been, you know, might have had today, yesterday as the first number one item. But I prayed for listing of two supplemental list. But the order has been passed 2 days by in January. Cover matter, my lord. Your lordship has passed.
No, you said that. You said that. I remember.
Yes.
But other side say matter request to be considered.
Other side, date of birth issue, the state has no. Only my
secondary education, man. Then Mr. Rao.
Yes, my notice was there also. Now he has come, but I told the truth. So,
but already signed yesterday.
I pray that in next week.
Within what will happen within? I do not know.
But since there is a covered matter, a doctor is suffering. So a doctor is for 2 months of inconsistent date of birth. A doctor is without employment. He is a doctor.
First, we have already passed the order.
Yes, sir.
I may pardon your lordship. I had mentioned 193, item 193 in the first order. It is a very small matter. It will take only 2 minutes.
Which is that? 193?
193.
Any urgency?
He is jobless since 2 years. That's why he is poor man and he belongs to SCBC category. And
the prayer.
Prayer is the only prayer is to the withdrawal of his resignation letter, which was rejected under Annex 5.
When did you apply? You applied on which date?
On 13/3/2023.
It was accepted.
No, it is not accepted till now.
What is the under rule position? How many days for acceptance?
Your lordship have a glance at Annex 5.
Who appears for the OPs? If resignation is not accepted,
my lord,
as long as it is not accepted, so long they can withdraw that.
My lord, correct. But we are handicapped. The files have not come.
First week of January.
Item, weekly list item 49.
History lordship in daily list. Stop, the first week of second week of January daily list. Let it be in daily list so that it will not, otherwise it will not reach you.
Item 49, my lord, I have already received the draft counter. If the time may be granted to.
Not that may be given because he is not getting pension, only getting provisional pension.
Second week of January.
That's
problem.
At the request of the who may file counter in the meanwhile. But second week it comes. Second date I cannot fix because I do not know. If I were to see, perhaps I would have requested. Yes.
Item 50. Weekly list item 50.
50. Which year? 24. 24. First week of February. Then appears first week. Petitioner call in first week of February.
Item 51.
Yes. May I please, Your Lordship?
Yes. No counter is there.
But here counter is not necessary. The point of law is involved. My lord, here the petitioner.
Any urgency?
But suspension period is to be regularized. But suspension was not approved. So under the second proviso to Rule 21(2) of the 1974 rules, if suspension was not approved, then he is deemed to be continuing in service and that period is to be regularized.
Any judgment covered by this?
Yes, the full bench.
But you say, let them take a decision. They have rejected your claim.
They have
Yes,
rejected.
rejection is under challenge.
Rejection is
Correct.
under.
But how, suppose if it is not approved, where the apex court said, where the approval is required for suspension or termination, unless approval is granted, it is no suspension, no termination.
And there is a full bench judgment also.
Yes. Have they referred to Supreme Court judgment?
No, they have not referred.
Take that.
Annexure 6.
You also kindly see.
Annexure 6 में kindly we
Paragraph
say.
9. Paragraph 9 of that judgment.
1 second. Annexure 6 we see.
My lord. Annexure 6 is the impugned order before your lordships. The lordship they have quoted. The petition, I am placing that, my lord.
No, that last reasoning itself appears to be wrong. See, he is under
Released on bail, so he did not.
He should work during the suspension period. Question is, the preconditions or post conditions for an event are complied with or not. Event is suspension. Law prescribes post conditions. If they are not, they are called in Transfer of Property Act, they are called condition subsequent. Condition precedent, condition subsequent, conditional limitation. 3 ideas are incorporated in Transfer of Property Act. In condition precedent, unless it happens, event will not take place. In condition subsequent, unless subsequent event happens, this will not take effect.
My lord, but here is a case, whereas it is evident from the above facts and circumstances, the petitioner have never rendered service in school for a period of absence from 13/7/2016 to 25/7/2017.
Because he was under suspension.
Yes. So, no, he was in custody.
No, I was under suspension.
Where you were
because,
yes, I was released on bail on 13/9/2016. Just after 2 months.
When you were taken to custody, when your client was taken to custody.
My lord.
Then that aspect is a different.
Yes. Your lordship, I clearly see the suspense of
custody period is to be excluded.
Yes, custody period is to be excluded.
How long you were in custody?
It is with effect from 13/7/2016 to 13.
No, that is not correct. But I was released on bail on 13/9/2016.
When was your client taken to?
My lord, Annexure 6 is clear.
Annexure 6.
Submitting from Annexure 6 only.
From 13/7/2016
to 13/9/2016. He has remained under jail custody with effect from 13/7/2016 to 13/9/2016.
No. My lord, I was taken to custody. Your lordship may kindly see. My lord, I was placed under suspension for the period from 13/7/2016.
My question is not one.
Yes. My lord, your lordship may kindly see. I was arrested in connection with a criminal case that because my wife made a complaint.
498A,
498A, 323, 494 and 34 of the IPC.
For Lordship Act also there.
Yes. Your lordship may kindly see the suspension order itself. Since I was
answering my question. Simple question. When were you taken to custody? When you were enlarged on bail?
My lord, I was taken to custody. My lord, I remained. I was enlarged on bail on 13/9/2016. Just 2 months before I was taken to custody.
Then what G says appears to be correct.
No, my lord.
13/7/2016, he was arrested.
Yes.
13/9/2016, he has been admitted to bail.
Yes.
Therefore, there is a deemed suspension.
No, my lord, that has been interpreted by the coordinate bench of division bench of this honorable court, because that provision is there so far as government employees are concerned.
No, that provision applies.
No, my lord,
in the absence of deeming.
My lord, your lordship may kindly see the judgment of
the rule first.
Yes.
Read the rule.
Section 297 is not applicable here.
No. Your lordship may kindly see the rules. The second proviso to rule 21(2). The 74 rules, page 992 of the manual. There are 2 kinds of suspension. One suspension by way of punishment and one suspension.
3 kinds of suspension.
Yes.
Suspension by way of punishment. So there are such rules.
Yes, suspension
In
pending-
contemplation of disciplinary proceedings.
Yes,
Suspension because
of involvement in a
tendency of
criminal case. Yes,
Then deemed a suspension.
yes.
Four kinds of suspension.
Yes, yes. My lord, so far as our rules are concerned, 74 rules, which is meant for the employees of aided educational institution, only two kinds of suspensions are there. That is suspension by way of punishment, which is a minor punishment. And second type of suspension is suspension at the initiation of the disciplinary proceeding for a period of 30 days by the management, pending approval of the district education officer in case of a school, and in case of a college, the director. Here,
If approval is not granted, from 31st day, he is deemed to have been, suspension is deemed to have
been lifted.
But 30 days, he will.
30 days,
Number one.
that power is there.
Is there a provision for a deemed suspension?
No. Under the 74 rules, there is.
Then you mean to say
Yes,
that even when he was in jail,
yes.
he should be given the salary.
My lord,
That will be obnoxious in service.
no, my lord. So that period is concerned, that period I may not get my salary. But so far as, my lord, so far as regulation of suspension period is concerned, here, please allow me. Here, my lord, I was placed under suspension for more than 1 year. Even though I was enlarged on bail and I submitted my joining report.
When did you give the joining report?
My lord,
Just show.
that is on. The suspension order was revoked on 26/7/2017.
Not this, kindly understand
Yes,
my English.
yes. My
When
lord,
did you make representation for revocation of the suspension?
revocation of the suspension order. Revocation of the suspension order, that fact is lacking. That fact is not there. But here, your lordship, may kindly see, admittedly, the suspension order was revoked, my lord, on 26/7/2017. I was placed under suspension for the period from 13/7/2016 to 25/7/2017.
You were during that period, you were in custody.
My lord,
Yes.
I remained in the custody for only two months. 2 months.
Therefore, I am asking you, when did you tell the management, I am now out of the custody?
Yes.
Kindly take me back to duty.
Yes.
Where is the proof?
My lord,
On which date, how they will come to know that you have been released? Unless you say.
that is reflected in the impugned order.
That's not the point.
But your lordship,
Unless law is settled is that.
yes,
Once he goes to custody,
yes,
if he says that I am released on bail, it is for him to show that he was released on bail and he reported for duty, despite that the management rejected the prayer. That's the law. Like Justice Rama's services under the state. The chapter.
My lord, my senior is not
no.
addressing to that.
No.
Lordship may kindly have a look to that Annexure 6.
Yes,
Annexure
I'm saying
6,
that.
Annexure 6, last paragraph of page 27. Whereas, though the petitioner released on bail on 13/9/2016, he did not report of joining before the headmaster of his school on the next day itself. As such, he remained unauthorized absent in his duty, that is from 14/9/2016 till 25/7/2017, which comes to 1 year 12 days. Whereas the management of the committee have accepted the joining report of the petitioner
after revocation.
On 26/7/2017, duly made a resolution.
To tell the manager, sir, I was taken to custody. Now I have been enlarged on bail. Kindly accept my duty report. When did you do that? Otherwise, how the management will?
Yes.
I will be laying down a very dangerous precedent if I agree with you.
Yes.
For rest of the people.
But your lordship is correct. When he submitted his joining report, that factual aspect is lacking. I will file an additional affidavit to that effect.
No, that
Lordship may decide it.
But if you have evidentiary material.
Yes, evidentiary materials. I will give.
On being asked when the petitioner on being released on bail on 13/9/2016, he had submitted his duty report learned counsel appearing for the petitioner seeks to produce evidentiary material in that regard as to when his duty report was submitted, and on such submission, it was accepted.
Yes.
Non-furnishing of material may lead to drawing adverse inference against the petitioner. First, call this matter in the third week of January 2026, as requested by counsel for the petition. Yes.
List item 52.
Give this to
52, my lord.
There is a, Mr. Sven, there is a book on law of suspension.
Yes.
There is a good book.
Yes.
Forgot the author's name. Long
So far as this point is, my lord, admittedly, so far as government employees are concerned, my lord, rightly my lord has said that there are 4 types of suspension. One is suspension by way of punishment. Second is suspension, deemed suspension if a person is taken to custody beyond 48 hours. And third is in contemplation of a disciplinary proceeding. So far as 74 rules is concerned, only 2 types of suspension. That is one, suspension by way of punishment, and second type is suspension at the initiation of disciplinary proceeding. My lord, exactly in a similar situation, my lord, an employee of an aided educational institution who was taken to custody beyond 48 hours, he was deemed to have been placed under suspension by the authorities. This honorable court, division bench of this honorable court, interpreted that law that
so ultimately the full bench said,
yes,
unless the rule authorizes, that cannot happen. That is your submission.
So far as CCA rules is concerned, that is ipso facto not applicable to the employees of aided institutions. That is the position of law. So unless the suspension order, if suspension order travels beyond 30 days, it requires approval of the district education officer. If it has not been approved for any reason, but the employee concerned is deemed to be continuing in service and he is entitled to get the benefit.
No, there are 2 aspects again.
Yes.
Whether suspension is revoked or not.
Yes.
If you are out of employment,
yes,
out of job,
yes,
then no relief can be granted to you.
Well,
there may not be suspension in the eye of law, as you rightly said now, assume it that way.
Yes.
Still, you will not be entitled to the benefit.
I may not get the salary, but that period is to be regular.
Suppose if you are to be in jail for 7 years.
Excluding that period, so far as other periods
are acquitted.
But excluding that period, so far as other remaining periods are concerned.
No, excluding which period?
But I remained in custody.
Correct. After that, you should come back to duty.
Yes. That aspect, my lord, is absolutely correct. Yes. That has to be asserted.
Even assuming that suspension is unjustifiable, you will not be entitled to.
My lord, that judgment, your lordship, may kindly.
Yes, I agree. Assuming that, I am saying that now. We will assume that you are right now.
Yes.
In terms of this judgment.
Yes.
But that will not entitle you to the benefit which you are asked. Because you were assuming that you were not suspended at all. But you went away from the employer.
Whether I have submitted my joining.
Otherwise, how the management will come to know that you have been released from the jail? You should go and tell the management.
Yes.
This is the bail order. I am come out.
That document is there. Otherwise, you would not have.
Is there? The document that you submitted the duty report.
Yes.
That is essential.
And they revoked the order much later.
Unless you.
Yes, I will bring. I will bring.
Yes.
List item 52.
52, my lord, let it come in the second week because I have not brought the file.
Third week of it. Yes.
List item 53.
Yes, my lord.
Yes.
Where is my lord? Yes. He will send the counter also not filed. But my prayer is a page 12, my lord. Kindly see, my lord.
Will you argue in the absence of counter?
This case, my lord, though they have approved my post as in the ISC paid, my lord, but I am till now from 27.
Requires counter, brother. Requires counter. Going by your prayer itself, because you want questionment of that order. But then it requires from the first week of February. First, in the meanwhile. counter if any will be filed, failing which petition amendments should be taken on, may be taken on face value. Yes.
Duty list item 54.
Yes, Lord. I'm challenging the order of my rejection under Annexure 11, wherein my claim has been rejected. I was before this honorable court. You also kindly see Annexure 8, page 51.
What the court said?
This honorable court, while disposing of the matter, I am reading
What it said?
Consider.
Then contempt was.
My contempt was filed and thereafter it was rejected. And I am relying upon the observation of this honorable court for a moment. While directing the authorities for consideration of my claim, this honorable court has categorically directed, however, it is observed that if similarly situated teachers who have been appointed persons to the said select list published in the year 1996 are continuing, the effect of such continuance shall be taken into consideration by the opposite party number 3 while considering the claim of the petitioners.
Yeah.
Similar, while considering my claim,
similarly circumstanced persons, if they are given benefit,
so
the benefit should be extra.
I should have been given the benefit, but they have rejected.
To whom it is given?
Yes, ma'am. The person under annexure, you let me kindly come to page 29. This person approached the London State Administrative Tribunal. His case was directed for consideration and accordingly he was given the benefit.
What is that regularization?
Yes, because my lord, in the year 1999, one set of persons were appointed and while they were continuing as such,
person who approached the OAT, he is on par with you. He was on par with you.
He was, my lord, sorry, my lord.
Person who approached the OAT,
my lord.
Was he on par with you?
Yes.
Date of entry is what?
Yes, ma'am. Page 29. The order of the online tribunal in respect of that person, my lord. Page 29. Biro Kishore Boria. From
So
the same.
When he joined service?
My lord, he joined service from the same selection in the 1999.
No, when he joined in the service.
Rejoined, my lord, after just. Yes, yes, at page 43. That is of the dated 24/11/2014.
24/11/2014. What is his name?
Biro Kishore Boria.
Spelling?
BIRAKISHOR. Bariha. BARIHA. Bariha.
Oh, he joined as what?
Joined as a primary school teacher, in Karua UGUP school.
And you joined on?
I had not joined. Initially, I joined in the 99. I was terminated without giving any opportunity of hearing or any notice, my lord. I was terminated.
Yes.
From that date, I have been approaching the court of law.
You were terminated when?
99, my lord.
2000.
Was terminated on which date?
That is the dated 22.
He was also terminated.
Yes.
They also.
Yes, ma'am. I was terminated on 22/4/2000. And from that date, my lord, I have been approaching the court of law, even including the state administrative tribunal. Number of cases I have filed. So after the abolition of the land tribunal, I approached this honorable court. 2 rounds of litigations I have filed here. And this is the last order what I read before lordship. The observation of this honorable court.
That if similar person is granted benefit, that if he is
I should be considered.
He was reinstated on which date?
That is in the 2014, my lord, I get that date. That is on 24/11/2014.
No, the date of entry into service.
No,
Termination.
that is the rejoining of that person. Rejoining of that person.
24/11/2014.
14.
Then again he was terminated.
No.
No, my lord.
Then he went to OAT for what purpose?
I'm submitting the fact, your lordship will be clarified. In the 1999, a set of persons were appointed by the then district education officer, inspector of schools, my lord. Near about thousands persons were appointed. Thereafter, the director of elementary education bring an allegation that the selection is illegal. Some of the persons were allowed to continue, and some of the persons were not allowed to continue. The person, those who are not allowed to continue, yes, I was amongst them, my lord. And accordingly, in the year 2000, I was terminated. From 2000, my lord, I have been approaching the court of law, and one by one document I am showing.
When is your date chart?
Date.
When date?
I'll provide.
Because so many dates.
Yes. I'll provide.
Date chart to be filed. Call is first week of February. Any other short matter? Or covered matter?
My case.
59 is covered. 59 is covered. Which is that judgment? I should know.
My lord, PET claiming intermediate Shipad scale up.
Client request to send order, will casting the appointed parties. Admission, that of eligibility. Person surviving working into partner.
By rejection order, my lord, Annexure 12, my lord.
Dated?
My lord, dated
16 to 2000.
2/4/2024.
Niranjan Naik's case.
2/4/2024. Annexure 12, page 51.
Was it in the one, Annexure 12.
My lords, that is order of passment. It will be hard, my lords.
Because Annexure 4, my lord, already all districts, my lord, they have already drafted the intermediate Shipad scale up.
Correct. But in hearing in the quashment matter, ordinarily we have to have the objection from their side because opposite bidder to be considered, etc. I would have said in terms of this considers. And if them will objection.
But item 56, the building is complete. Since for 18 years of completion of service, they are not regularizing service matter. This is a second time litigation. And everything only your lordship fixed up a date that it can be disposed of. A date may be fixed.
Third week of January. Third week of January.
Not even date may be fixed.
Date I cannot fix because I do not know whether I will be in this roster. I cannot fix a date for my brother. Chief Justice, Honorable Chief Justice can do it.
This covered by the Jago versus Union of India.
That is, yes, week I can do. Yes.
One matter, item
75 matter.
We have a reference meeting.
Yes.
Yes.